नमस्कार, फेस टू फेस प्रोग्राम में आपका स्वागत है। मैं हूं इंद्रजीत बधवार और आज मेरे साथ एक बहुत ख़ास मेहमान है। ख़ास इसलिए नहीं कि वो एक नौजवान अधिवक्ता हैं, लॉयर हैं, बट ऑल्सो चिंतन चंद्रचूड एक हमारे देश की बहुत ही मशहूर फैमिली के डिसेंडेंट हैं, लंदन में ही रहते हैं। इन्होंने अभी एक किताब लिखी है जिसका नाम है बैलेंस्ड कॉन्स्टिट्यूशनलिज्म, द कोर्ट्स एंड लेजिस्लेचर्स इन इंडिया एंड द यूनाइटेड किंगडम, जिसपे असल में काफ़ी चर्चा हो चुकी है, जिनको हमने पढ़ी हैं और जिनको लॉयर्स ने पढ़ी हैं यहाँ पर और एकेडमिक्स ने पढ़ी हैं और काफ़ी उससे प्रभावित हुए हैं वो। मैं चिंतन से सबसे पहले ये सवाल करना चाहता हूँ कि देखिए, पहली बात, it looks like the educational bug has bitten you. I mean, you have a PhD in law from Cambridge. Right. You have degrees from Yale, Oxford.
Yes, that's right.
Good God, Oxford, and before that, Bombay Law School, right?
Bombay, yes,
Bombay.
Government Law College in Bombay.
What made you continue to pursue, one educational standard after another? I mean, what is it that drove you constantly into academia, so to speak?
Right. So the intention after I left Bombay to study at Oxford was to do a master's for a year, a program that they describe as the BCL, the Bachelor of Civil Law. A few months into the program, I realized that I had some serious intellectual appetite which couldn't really be satisfied in the course of a year.
It's an insatiable appetite, it seems to me.
It's an appetite which I think is now drawing to an end since I've begun practice a few months ago in London.
जिसको शिक्षा की भूख जिसे कहते हैं, वो इनकी भूख कभी मिटती नहीं है, बट कह रहे हैं कि अब शायद थोड़ी मिटनी शुरू हुई है, बट वो शिक्षा की जब भूख मिटेगी आपकी, तो फिर आगे जाके किस चीज़ की भूख लगेगी?
आगे जाके, well, to start with, I'd say two things. You're always studying, you're always learning as a lawyer. So to say that the learning process ends is incorrect, it just takes a different shape. Aside from that, of course, I've begun practicing. So I'm practicing at a law firm in London by the name of Quinn Emanuel Urquhart Sullivan, and it's one of the leading international law firms which is headquartered in Los Angeles.
How much active pleading have you actually done?
I've done a fair amount. The good thing about the firm is that you get plenty of opportunities to do a wide range of work, really. So we do a lot of both domestic high court litigation in the UK as well as international arbitration.
But are you a rare species there, Chintan? Because of course, I mean, the world over, we know that Indians are in IT, they're doctors,
yes.
Of course they're teachers, but in the law profession, even though increasingly a lot of Indian lawyers are going from here for arbitration and opening offices there, and we'll talk about that.
Yes.
But what about Indians or people of Indian origin, no matter what their nationality, but people of Indian origin, you don't find too many of them actually as pleaders and solicitors living and practicing in a place like London. So are you considered a bit of a rare bird over there as an Indian?
There is a burgeoning community, I'd say, of Indian lawyers in London now. Perhaps until a few years ago, you wouldn't see many Indian lawyers in London.
Yeah.
Things are changing now. So for instance, you do have networks of Indian lawyers that get together from time to time because you can actually describe them as a community. Now this is of course a fairly recent development, and you see more lawyers, for example, on the corporate side than on the dispute side. But I think as really the legal market is becoming more and more internationalized, you'd certainly notice a greater crossover of both Indian lawyers into the UK as well as UK lawyers into India once of course the markets open.
Because actually the platform and language, thanks to Roman jurisprudence and convention and case law, is pretty much the same, isn't it? I mean, in term, because even judgments over here, including some pronounced by your grandfather, many of them pronounced, of course, by your father, have reference to Canadian precedents, they have reference to European courts increasingly.
Right.
The EU doctrines that are accepted, and like human rights doctrines that have been accepted in EU in the Declaration of Rights,
right.
the expansion of Article 21, for example, of,
right.
of the Indian Constitution.
Right.
How much more of this internationalization
right.
do you think will go on? And that
right.
will bring me to
Absolutely.
the subject of your book.
Sure. I mean, so what we've noticed, particularly in recent years, is an increasing globalization of the law.
That's a beautiful word. That's what I was trying to get at.
Where, in a sense, there's almost a fear of remaining in your own silo, and there's a great attraction associated with looking at how other legal systems or different legal cultures solve problems.
Can you give me an example of any judgment from India that has been cited in any foreign court, any significant foreign court?
Sure.
Anything that comes to mind?
So, Indian judgments are very commonly currently cited in South Asian foreign courts. You see this all the time. The basic structure doctrine, for example, is very, very frequently cited.
You are referring to Keshavanand Bharti.
The Keshavanand Bharti case, of course, is frequently cited, whether, of course, in agreement or disagreement. That's a separate question. But it's cited as an authoritative source of the law. It's been cited in Bangladesh, in Pakistan, Sri Lanka, and several other jurisdictions. Now, we need to be slightly cautious of this, of course, because there's always a danger of citing cases from a jurisdiction whose law you agree with.
But doesn't this, what you seem to suggest here is that a lot of this sort of comes full circle.
Yes.
Now, Keshavanand Bharti also certainly drew a lot of his inspiration from some of the concepts enunciated, well, of course, going back to the Magna Carta, of course. Right. It cites the Magna Carta, in fact, it talks about it.
Absolutely.
But certainly some of the great constitutional debates that took place amongst the founding fathers of the American Constitution.
That's right.
So it seems sometimes this thing comes full circle if Keshavanand Bharti is also being cited in an American context.
Right.
But the basic spirit of that is कि जो Keshavanand Bharti के जो जिस याचिका के बाद केशवानंद भारती के में प्रोनाउंसमेंट आई थी, इसकी आत्मा वैसे जो है आप कहेंगे इसकी लीगल, इसकी कानूनी आत्मा जो है वो कहाँ से जुड़ी हुई है?
Right. So in a sense, I mean, Keshavanand Bharti provides you with a paradigm example in a sense. Because on the one hand, it did cite several other jurisdictions' case law. It cited legal authorities. It cited philosophy from other jurisdictions. On the other hand, the sea change that you notice after Keshavanand Bharti was that at the time that it was decided, which was in 1973, it was very unusual, or it was thought of as being unusual, for a constitutional amendment itself to be declared unconstitutional. That was thought of as being a paradox.
Now, that brings me to a question that you that you had already answered in one of the interviews I saw of yours.
Yes.
And I want you to relate this to that. Now, when you were asked about the NJAC decision by the Supreme Court, where it was a direct confrontation with the legislatures. They just knocked it out.
Right.
And when you were asked what effect this would have, you said, look, it's still being played out.
Yes.
If I remember correctly.
Yes.
Number one, I want you to dwell on that. Tell me why you think it's still being played out.
Right.
And number two,
right.
Would you put it in the context of Keshavanand Bharti?
Right.
Is that still being played out? And if not, what actually were the lasting impacts, or have been the lasting impacts of Keshavanand Bharti on the Indian political and social atmosphere? I'd like you to take both these questions, because you do see them as related, don't you?
Most certainly, certainly. Now, what I mean when I say that it's still being played out is that very often, and this is really what I consider the book, this lies at the heart of the book, you only really fully appreciate the significance of a judgment 2, 3, 4, maybe even more years after the judgment is pronounced. Since the NJAC judgment, there has been uncertainty really about what process would be followed. Because we should be clear about one thing. On the one hand, the constitutional amendment was struck down by the court. But that didn't mean that the court said that it must be business as usual. So the court did indicate in its judgment that there must be some changes, and that the existing system of appointments was flawed and problematic. Now, what that means is something that we need to see transpiring over the next year or two. So therefore, to try and fully analyze this, we need to wait a while. is my view. Now, where Keshwanand enters into this picture is quite interesting. Because on the one hand, Keshwanand was viewed as a safety valve. So what many people perceived the basic structure doctrine to do was really to protect the state from a 1970s type situation. So in other words, a situation where the doctrine wouldn't really be used very frequently. And up to NJAC, it hasn't in fact been used too frequently. And it would really be used quite sparingly and in exceptional cases. You could argue, and many people have argued, that the NJAC case is not quite one of those exceptional cases. That it wouldn't necessarily result in the collapse of democracy, for instance, in India. So we're really seeing in many ways a reshaping of the Keshwanand doctrine in the NJAC case. One of the reasons for this is that in the Keshwanand case, they focus on broad overarching principles. In the NJAC case, they try and bring those broad overarching principles down to the ground and try to explain what those principles will mean in practice. So it's really it's an explanation of the Keshwanand Bharti case brought 10,000 feet.
You're linking, I think you've linked that. I have not seen it linked so beautifully and in such simple language, even though I've asked many people as a journalist the very same question.
Right.
Apart from Keshwanand Bharti, could you cite some other cases that have really, or some judgments that have really, and if they come even from your family side, doesn't matter. We're talking as lawyers. I mean, they're lawyers and they lived in a different time, and which you would say was seminal, which helped shape Indian society, or to move it forward in what you would consider to be a progressive direction. And what then I would ask would be your opinion as a doctor of law, and certainly as a person who constitutional law, I mean, of course fascinates you. What would be your definition of progressive? It's a loaded question.
So the first judgment that really comes to mind, and this was in a sense a follow-on from the Keshwanand case, is the Minerva Mills case. And people often don't understand the significance of the case. What happens after the Keshwanand Bharti case is that the Constitution is amended once again. Article 368, which is our amendment clause, is amended to categorically reject the analysis in Keshwanand. In Minerva Mills, and what's crucial about this case is that the Supreme Court's interpretation of the Constitution changes. All the way through up to and including Keshwanand, the court had been interpreting the Constitution in a textualist fashion. So in other words, focusing on the words used in the text, the language of the Constitution. In Minerva Mills, if they had stuck to the text of the Constitution, they would have had little choice but essentially to say that Keshwanand was no longer good law. But what happens in that case is that the court moves more to a structuralist interpretation of the Constitution, focusing less on the language used and on the words used, and more really on the institutions of government and the scheme of the Constitution itself. I think that is really one of the major landmark cases in Indian constitutional law. I'm highly skeptical of some of the recent judgments of the Supreme Court. But one recent example from the Delhi High Court which I'd like to cite is the Nas Foundation case, in which, in a fantastic judgment by Justice A.P. Shah, the court reads down section 377.
I think you mentioned that in your book, don't you?
I do. Yeah. I discuss it at some length in the book as well.
Yeah. Could you in just summarize that?
Sure.
Your point of view on this case, as is mentioned in the book, in a couple of minutes, if you can.
Sure. So my major concern about Nas Foundation, absolutely, and the Supreme Court's judgment in that case was that it involved an abdication of responsibility by the Supreme Court. The Supreme Court almost seemed to suggest that there is a numerical de minimis associated with the protection of fundamental rights. In other words, if you don't constitute the right numbers, you're not entitled to protection.
Now, given the system of appointments, which system do you think leads to a situation in which the judiciary can help, along with the legislature, not necessarily as an adversary, but playing an adversarial role when necessary, to lead you into this so-called ideal of progress?
Okay. I think there are problems with each of the three systems of appointments. We're familiar with what the problems with appointments in India often are, which is, lack of merit often. It's often perceived that judges who should be in the Supreme Court aren't necessarily in the Supreme Court. Many of these arguments have often been made with reference to the NJAC case. But for instance, in the UK, where the appointment system was relatively recently changed, there are still problems. So for instance, at the time that the constitutional changes were made in the UK, there was only a single woman Supreme Court, or House of Lords judge at the time, who was Baroness Hale. Today, more than 10 years later, Baroness Hale still remains the only woman on the UK Supreme Court. So there are problems really associated with both systems. I think the larger constitutional framework in both systems, however, and this is what I try and argue in my book, does provide for a greater collaboration between courts and legislatures in the UK rather than in India. The way I look at it, it's not necessarily a problem for courts and legislatures to be adversaries in some sense, or to assert different interpretations of the Constitution, so long as that's within reason and within limits. In the UK, what tends to happen is, because of the interesting nature of the remedy, let's remember that
what is the remedy? Yeah.
So British courts don't have the power to strike down primary legislation emanating from Westminster Parliament.
I see, yeah.
So in other words, all they can do is to make a declaration of incompatibility, which is under Section 4 of the Human Rights Act, indicating that Parliament should change the law. And then, at least in a formal sense, it's up to Parliament to decide whether they wish to change the law or not. Now, this produces some interesting effects, because what often happens is that in situations in which a court, even empowered with a stronger power to strike down legislation, thinks that power might have serious effects, might have collateral consequences, it's reluctant to use that power.
And it's all the more difficult to do that in England because it doesn't have a written constitution.
Exactly.
So here the constitutional interpretation or even misinterpretation by the judiciary will at least have something to lean on in terms of Article A, B, C, D, X, Y, Z of the Constitution.
Right.
But in England, what are you going to rely on? Lord Acton or Denning or what? What are you going to rely on?
So now the Human Rights Act has incorporated the European Convention on Human Rights.
Yes.
So the schedule to the Human Rights Act contains many of these rights. So in a sense, even though the Human Rights Act is perceived as an ordinary statute, many people do conceive of it as a bill of rights.
Yes, that's very important what you just brought up.
Right.
Because politically, I mean, can they reject the acceptance of European Commission doctrines and after Brexit?
Right. So it's interesting. But one of the immediate fallouts of the Brexit vote, or even the Brexit referendum really, was less of a focus on the Human Rights Act. Because what happened leading up to the 2015 elections...
because it has a lot to do with immigration too, right?
Absolutely.
I mean, that's the unstated...
absolutely. That's
the unstated racism.
That's right. One of the real sticking points leading up to the 2015 general elections in the UK was what would happen to the Human Rights Act. The Conservative Party in its manifesto had in fact promised to repeal the Human Rights Act altogether. The Brexit vote temporarily has shifted the focus away from the Human Rights Act. And so has in some sense given some relief to human rights advocates for the time being. Of course, this is only temporary relief. This is not long-lasting balm. So the situation might well turn back to the Human Rights Act once we get a clearer picture of what's going to happen with Brexit. As of now, of course, there's a great deal of uncertainty about what Brexit means, what the UK's relationship will be with the EU. But once those issues get ironed out, we might come back to this difficult question about what the fate of the Human Rights Act will be. And so, notwithstanding all of my praise for the Human Rights Act, one of the major concerns associated with this model of constitutionalism in general is the fact that such statutes can be repealed by ordinary majority.
But in India, where you have a very strange concept where the legislature is actually a slavish extension of the executive.
Right.
The minister cannot judge himself. And you're again getting into a situation here, which I believe to be a flaw in our system, of that the king can do no wrong.
Right.
And executive privilege being ingrained into the Indian system.
Right.
Now, in a system like this, the only way where you have a runaway executive is the judiciary. Who else can check them? I want you to comment on this.
Sure. So I see the argument you're making, and my thoughts on this subject of judicial activism are quite clear. My view is that it depends on what kind of activism we are talking about. If the court, on the one hand, is making incrementalist judgments which are relatively easily implementable and which can be enforced on the ground, which are in consonance with constitutional principle, then that's an activism that we should welcome, for instance. The problem with the term is that it's used quite loosely, and so therefore it really covers a wide gamut of activities. If we were to compare it to other judgments in which the court very often prescribes guidelines, prescribes legislation, which becomes very difficult to comply with, that tends to denude the institutional authority of the court itself, which is really a very precious commodity. Some of the judgments which have in fact often been praised, I criticize in my book. And a good example of this may be the Vishakha versus State of Rajasthan judgment, in which the court prescribes guidelines for sexual harassment in the workplace. Now, undoubtedly, the intention is noble, and no one can question that. The court had good thoughts in mind at the time. For several years, for over 13, 14 years, the judgment was not complied with. The Supreme Court itself, public authorities, institutions, didn't set up grievance redressal committees in accordance with the court's judgment. This is simply because the court lacks the equipment, the court lacks the infrastructure that Parliament possesses. The failure to observe the court's judgments, in my view, seriously erodes its authority.
Excellent point. And this is something we were talking about before we sat here. I'm glad you kind of steered me into this direction, because that was going to be my next question, and I think your very illuminating answer leads me to the next one, which is precisely why, when there are judgments that are seemingly set in concrete, like the S.R. Bomai case, which has to do with center-state relations, and in which there's just one example, in which it is absolutely crystal clear that the acid test before a governor can dismiss a government, a duly elected government, has to be a floor test, has to be proved in terms of majority, and yet you've seen in this year alone in India, in the northeast and then in Uttarakhand, and that repeatedly courts, this is one example only, will continue to take up and reopen cases which have been decided by constitutional benches. Why doesn't the Supreme Court come down much harder on these judges for doing this? Why is it that we continue to see cases going back to the Supreme Court, to double benches, and then again to the constitutional bench on some matters in which the courts have ruled very firmly? I think there's something flawed here.
I think there's certainly much to be said about the structure of our courts at this stage. To start with, our court, the Supreme Court, is under tremendous pressure, and we need to be mindful of that. On the one hand, it is an attraction, and I think it is necessary, in fact, for scholars, for academics, for practicing lawyers, to criticize the way in which the Supreme Court is functioning, the number of cases it takes up, and the authorities that the number of canonical cases even that it decides from time to time. So one of the things that I've said in my book is that whereas if you compare it to the US or the UK Supreme Court, where it's relatively straightforward to track important judgments made by the court, it is extremely difficult to keep a track of all significant judgments passed by the Supreme Court from day to day. And therefore what tends to happen is that even important judgments, important decisions made by the Indian Supreme Court tend to fall under the radar. And this really covers a large part of the spectrum, whether it's academics, whether it's other courts, whether it's practicing lawyers, surely because of the numbers. Now, of course, the good news is that we may well know what part of the problem is. The bad news is that we don't really know what the solution is.
But isn't this also part of the problem of backlogs?
Right.
And backlogs ultimately, pendency as they call it here, is a huge problem because it's actually the denial of access to justice. Do you see any light at the end of the tunnel? And don't you see this as a gross injustice to the people of India itself?
Right.
I mean, where else do you see a problem like this?
Right. This is undoubtedly a serious injustice. I think one of the fundamental problems in terms of principle with our system is that we focus or we emphasize too much on getting it right and not enough on getting it right on time. So, for instance, several other jurisdictions now recognize one of their fundamental principles of civil justice to be that a case must be decided, of course, correctly, but must also be decided promptly and at a proportionate cost. That needs to be inculcated into our system from the ground level up. That means making changes really across the board, whether it's in terms of increasing the number of judges, setting time limits on trials, changing the way in which adjournments are granted, or deciding in which cases you should or should not be allowed an appeal.
Chintan, who would do this though? Who would make this reform? Should it come from just pressure from the judiciary? Of course it should come from the people. It's already there from the people.
Yes.
But who do you really see belling the cat?
Right. Unfortunately, the state of affairs that currently exists in our nation is that it has to be a combined effort. I think, for instance, for the legislature or the executive to try and attempt to make these reforms wholesale, independently, would be extremely difficult and in fact would be wrong. It must be a collaborative exercise between the legislature, the executive and the courts. Now, of course, this is not easy.
One initiative that I think can certainly come from within the judiciary, which would make a difference to the disposal of cases and justice, this constant changing of benches.
Right.
The trouble is that institutional memory is lost.
Yes.
There's a judge who understands the case, understands it beautifully, right? Then suddenly the case is postponed for 2 weeks and 3 weeks.
Yes.
Out comes another judge or a double bench.
Right.
It's like they've never even looked at the files.
Yes.
They don't know what has happened in the past and they're beginning afresh.
Yes.
And a judge who's been able to see through the various tricks that lawyers play or where they're trying to mislead or misinterpret the law or even mislead the judge, which I guess is also the function of lawyers.
Right.
It's a game that goes on.
Right.
So you'll see the judgment change in midstream, which then casts unnecessary aspersions on the integrity of the system and of individuals.
Right.
How do you see this changing? I mean, there used to be that part heard thing in India. They don't use it much now because a lot of judges who did that were accused of saying, oh, he has a vested interest in this and that's why. So now they don't put part heard.
Right.
The lower judiciary, for example, does not give bail where it should, because they think that it might reflect badly on their ACRs later on.
Right.
So now, aren't these changes that can come from within the judiciary itself without any pressure from the outside?
They can. There are, in fact, some low-hanging fruit which I think we should grab on to.
Is this one of them?
One of them may well be, for instance, setting up a specialist judiciary. And again, this is associated with so many of the pressures that are placed on our judges. Our judges are often hearing tax cases, criminal appeals. The amount of pressure and the expertise that we demand of them is really unrealistic.
And the biggest litigant is the government.
Absolutely. Absolutely. And of course, the problem there being that the government is itself afraid that if they don't appeal, there'll be accusations that may be made against them, for instance. So these are really some of the problems.
Okay, I think we've covered a tremendous amount, and it's been inspired by a book. I want to show this to our audience again because one last question.
Sure.
Has your father read this book?
Most certainly he has.
If he hasn't, and if the honourable judge is watching this program, which I hope he does, sir, I would urge you to read this book by an extremely talented young man. Thank you very much, Chintan. I really enjoyed having you.
Thank you very much. Thank you.